So good afternoon students, welcome you all to StudyIQ IAS English. My name is Vishal, I'm a faculty of Law Optional and Indian Polity at StudyIQ. Students, in today's class, we're going to discuss how Tamil Nadu is still able to provide 69% reservation. Yes, we all know that the Supreme Court in Indra Sawhney judgment has clearly stated that reservations cannot be provided beyond 50% of total seats in a provided year. Then how Tamil Nadu is still able to provide 69% of reservation in seats belonging to medical colleges, educational institutions and in appointment to government services. In this video, we are going to discuss the history of reservation, particularly in India, the Indra Sawhney judgment and how Tamil Nadu, despite the judgment given by the court in Indra Sawhney in 1992, is still able to provide 69% reservation. So please watch this video, because whenever I teach any topic related to reservation, whether I will be teaching article 14 or 15 or 16, the single question that I come across nearly every class is that how Tamil Nadu is providing 69% reservation. Because when I teach Indra Sawhney judgment, it clearly states that the state can provide reservation. The state has been given authority by the constitution itself to provide reservation. But the reservation that is provided on the basis of social and educational backwardness, it cannot exceed 50% of total number of seats in a particular year. Apart from EWS, because EWS quota was introduced in 2019 by a constitutional amendment, so the reservations that can be provided under the category of social and educational backwardness is 50%. Then how Tamil Nadu government is still providing 69% of reservation? So please watch this video and all your doubts regarding 69% reservation in Tamil Nadu will be cleared in a short span of time. See, when I talk about Tamil Nadu or the former state of Madras, because obviously before independence we had the state or presidency of Madras. So the Madras presidency, it has a long history of reservations. It has a long history of affirmative action. There was a party by the name of Justice Party, and Justice Party has taken its motto so as to provide affirmative action to the backward section of society. We all understand reservation is a medium of affirmative action. Now, what do we understand by affirmative action? We'll just take 2 minutes and I'll make you understand what is affirmative action and why it is important. Students, try to understand. In India, we have a long history of social discrimination. In India, due to certain system, there were certain sections that were historically discriminated against. That means they were not allowed to access education. Obviously, when they'll not be allowed to access education, obviously they'll not be able to gain some gainful employment or meaningful employment. Because of that, they remain educationally poor, and because of that, they remain socially and economically poor. So in India, there was a system, there was a vicious circle in which generation after generation, certain sections, they were discriminated against socially, educationally and economically. Because of that, certain sections remained backward perpetually. So now, when Justice Party came into power in former Madras before independence, so it took as its motto to provide reservation, to provide affirmative action. Now, the objective of affirmative action was to ensure that the societies that have been discriminated against, now because they are educationally deprived, they are socially deprived, so the people belonging to these particular societies, they will not be able to compete with rest of the societies in an open competition. So that's why they need to be provided with certain special benefits. So the Justice Party provided the special benefits or affirmative action in the form of reservation in admission to education institutions and in or reservation for government services. Now, after independence, obviously the government carried the same framework, the same political ideological framework. The government provided reservation in Madras. Now what happened? There was an important case by the name of Champakam Doraijam, State of Madras versus Champakam Doirajan, 1950. It's a very important case. It's a very important case. If you are a student of UPSC, you must be aware of that particular case. Now what happens? Students, I would like to tell you, under Article 15, initially we had only 3 clauses, 15 clause 1, 15 clause 2 and 15 clause 3. We only had 3 clauses. Now 15 clause, there was no 15 clause 4, no 15 clause 5, no 15 clause 6. These were added later on, right? So when the case came up in 1950, the backdrop of the case was that the state of Madras provided reservations in education institutions, especially in engineering and medical colleges, on the basis of caste. On the basis of caste. Now, as there was no article 15 clause 4, 15 clause 5, now these articles enable the state to make special provisions for socially and educationally backward classes, SCs, that is scheduled castes and scheduled tribes. And these special provisions can also extend to providing reservation in admission in education institutions. But these provisions, they were added later on. That means in 1950, there was no article 15 clause 4, no 15 clause 5. Now, when the state of Madras provided reservation only on the basis of caste, only on the basis of backwardness, now it was challenged that it is violating article 15 clause 1. 15 clause 1 simply states, state cannot discriminate on the basis of religion, race, caste, sex, place of birth. And the court said yet, the court said you cannot provide reservations only on the basis of caste because it is violative of article 15 clause 1, because then there was no article 15 clause 4, no article 15 clause 5. Now the government became very alert, and the union government or the parliament, it put forward or it brought in a constitutional amendment and inserted article 15 clause 4. Now this 15 clause 4, this article allowed the state to provide special provisions or to make special provisions in the favor of SCs, STs and socially and educationally backward classes. Now on the basis of this provision or under the authority of this provision, the state was allowed to provide reservation. So Champakam Dorajan case, it just impelled the government to insert under article 15 clause 4. That means initially when the constitution was framed, there were no reservations in education institutions. There were only reservations under 16 clause 4 in appointment to government services. So the constitution makers, they never envisaged that reservation shall also be provided in education institutions. They only envisaged under article 16 clause 4 to provide reservation in appointment to government position or to government post. Now moving forward, as Tamil Nadu had a history of reservation, and I told you the government inserted article 15 clause 4 and it clearly enabled the state to provide reservation in education institutions on the basis of caste to social and educational backward classes, scheduled caste and scheduled tribe. Now in 1980s, the policy of reservation, it was further extended by the then government that was holding power in Tamil Nadu. So during MGR regime, now MGR obviously is a very prominent political face in, he was a very prominent political face in Tamil Nadu. Now during MGR regime in 1980s, the government extended reservation. So the government provided approximately 69% of reservation. Try to understand. And this is the scenario of 1980s. So the government was so keen on the policy of reservation that it provided 69% of total reservation. That means for any year of admission or for admission belonging to a particular year, 69% seats in any education institution was reserved for backward classes, most backward classes, scheduled caste, scheduled tribe. Now, till now, what we have learnt in 1980s, Tamil Nadu had approximately 69% of reservation. Now, what was the concern about this percentage? The concern about this percentage was that the percentage is quite high. That means if 69% of the seats in any particular year will be reserved, now the students or the candidates belonging to the general or unreserved category, now this is highly discriminatory against them. So there was a concern among the community. There was also a cause of concern. There was also concern among the courts, because in another case just such as Balaji versus State of Mysore, in this particular case the court has given an observation. The court said reservations can be provided by the state has the power to provide reservation, but there shall be a ceiling. The state cannot go on and provide very high amount of reservation because it will be discriminatory against the rest of sections of society. Now, Now in 1990, there was a now in 1990 the political scenario of India, or what we can say the political background of India, underwent a very sudden change. What happened in 1990? The VP Singh government, obviously VP Singh was the Prime Minister of India, Vishwanath Pratap Singh government, it decided that it will provide 27% reservation to OBCs, other backward classes in government jobs. 27%. Now, before that, reservations were only provided by the central government to SCs and STs. Now, the VP Singh government decided that it will provide 27% reservation in the favor of OBCs. Now, it resulted in the reservation limit, or the amount of reservation extending sky high. It resulted in the reservation limit extending sky high. Now, obviously, there was uproar among the community. There was uproar among the candidates, among the students, especially from the unreserved section of society. Now, to challenge this particular order, the case was filed. The name of the case was Indra Sawhney versus Union of India. Now, in this particular case, the court decided. The court said, okay, if the state is willing to provide 27% reservations to the OBCs, the state can provide. The state has the power under Article 15 Clause 4, 15 Clause 5, and till then 15 Clause 5 was not inserted. 15 Clause 4 to provide reservation, as well as 16 Clause 4 to provide reservation to other backward classes. But it is also essential that there shall be a ceiling on the reservation that is provided. The state cannot go on and provide 70%, 80% of reservation, because it will be discriminatory against the rest of the section of society, because now they will feel discriminated. And obviously, if a state is providing reservation, that means state is taking a share of one community and the state is taking this share to another community. So somehow it is discriminatory. But as we have to improve the position of the backward section of society, so we need to provide reservation, but it shall be in limits. So the court provided that the state can only provide 50% of reservation in any particular year. And the court stated, but this ceiling of 50%, it can be breached. It can be breached in exceptional situations. For example, if in a particular state or in a particular area, in a particular stage, if there is a backward community and the population of backward community is 80%, 90%, 75%, that means the population of backward community is quite high. So in that particular scenario, the state can breach this 50% ceiling, and except these few particular exceptions, there will be a ceiling of 50%. So there was a general rule of 50% that can only be breached in the cases of extraordinary social and educational backwardness. Now, when the Indra Sawhney judgment came in, now the reservation provided in Tamil Nadu, 69% reservation provided in Tamil Nadu. Now, there was a concern among the political community and the general populace in Tamil Nadu that the 69%, obviously it is far beyond the 50% reservation as enunciated by the Supreme Court. Now, what happened? Tamil Nadu government, it requested the parliament to pass a constitutional amendment and put a law that allows the Tamil Nadu state to provide 69% reservation in 9th schedule. So now what Tamil Nadu did to save 69% reservation provided by it first enacted a law. The name of the law was Tamil Nadu Backward Classes, SCs and STs, Reservation of Seats in Educational Institutions and Appointments in the Services under the State Act 1993. Now, Tamil Nadu government enacted a law. The name of the law is, I have already narrated. Tamil Nadu government enacted a law and the parliament put this particular law in the 9th schedule. Now, this is the catch. Now, as this law was put in the 9th schedule, so that means now this law, it cannot be challenged on the grounds that it is violative of Article 14 or any fundamental rights. So now the law that enabled the Tamil Nadu government to provide 69% reservation, now this law was put in 9th schedule and this law was saved from challenged on the grounds of violation of fundamental rights. So now this is the 9th schedule till now is protecting the Tamil Nadu backward classes SC and ST Reservation Act. And because of that, Tamil Nadu government is still able to provide 69% reservation. Moving forward, now what happens? Again there was a new catch. Again there was a new catch, and we have a judgment called as IR Kolo versus State of Tamil Nadu. Now in this particular judgment, the Supreme Court said that ninth schedule, it is not beyond judicial review. That means if any law is put under ninth schedule, it does not mean that the law is beyond judicial review. The law can still be reviewed. The law can still be struck down by the court if the law violates basic structure of the constitution. Now this was a very important piece of judgment, because till now the Tamil Nadu law that was providing 69% reservation, it was being saved from being struck down by the court under the strength of ninth schedule. But in IR Kolo judgment, the court categorically stated, even if a law is inserted in ninth schedule, or even if a law is given the protection of ninth schedule, it can still be challenged. It can still be struck down if it violates the basic structure of the constitution. That means the law that enabled the Tamil Nadu government to provide 69% reservation, it was again open to scrutiny by the court. Now this was again the questions were raised on the constitutional validity of that particular law. Now what happens? In 2010, the Supreme Court said that 69% reservation can be challenged, but we are providing you 1 year. In that particular 1 year, you have to bring us data, because you are giving 69% reservation. So that means you have to show that in Tamil Nadu, the population of backward classes is quite high. The population is quite high. The population is approximately 70%, 80%. If you are able to show that there is a quantifiable data that provide that the population of backward classes in Tamil Nadu is 70%, 80%, then we will allow 69% reservation. Otherwise, we will stuck it down on the basis of Indra Sawhney judgment. Now, the court said it is the duty of the state government to conduct a caste survey. Now, at that point of time, Karunanidhi was the CM of Tamil Nadu. He was the CM of Tamil Nadu, and he did not take any effort to conduct caste survey, because there might be a condition in which he might be apprehensive that if we conduct a caste survey and if the population of backward classes, if it comes near 50%, 55%, 60%, then we will not be able to sustain 69% reservation. So the government was apprehensive. Of conducting caste survey, because they were having concern that if the population of backward classes is not as high as we are portraying, it will result in the court striking down 69% reservation. Now, after Karunanidhi, Jayalalitha government came, and again she did not conduct caste survey. She also refrained from conducting caste survey. Rather, she just quoted a commission report. So the government has appointed Amba Shankar commission report. So the government has appointed Amba Shankar commission, and the commission has given a report that in Tamil Nadu, the proportion of backward classes is approximately 67%. So the Jayalalitha government, it did not conduct a caste survey. It only quoted a report that was provided by Amba Shankar commission that said that Tamil Nadu has 69% of backward classes. Now, the thing here is the 69% quota. So now we are in the final stage of understanding the particular issue. The 69% quota, it can still be struck down. The only thing is we require a caste census in Tamil Nadu. So if there is a caste census in Tamil Nadu, and if the population of backward classes in Tamil Nadu, it comes near 40%, 50%, 60%, the Supreme Court will strike the quota down. But if the population comes near to 70%, 75%, then there is a possibility that the Supreme Court will allow 69% of reservation as stated in Indra Sawhney judgment, because now the state of Tamil Nadu will come in exceptional category. So the only thing that is saving 69% of reservation in Tamil Nadu is caste census or caste survey. If and when the caste survey is conducted, 69% quota will be open to scrutiny by the court. So this is how Tamil Nadu is still able to provide 69% reservation in education institutions as well as government services, and it is still surviving because the only thing that is lacking is caste survey, and if due to caste survey quantifiable data comes in, then the 69% quota will be under the scrutiny of the court. So in this video we have tried to understand the reservation, Indra Sawhney judgment, how Supreme Court has ordered in Indra Sawhney judgment that reservation cannot go beyond 50%, but how the 69% reservation provided by Tamil Nadu government is still surviving despite Indra Sawhney judgment. So I hope you were able to understand how Tamil Nadu is still able to provide 69% of reservation. I hope certain concepts that you were concerned about, or certain concepts that many students were in doubt, these concepts have been cleared by the help of today's video. So we'll wind up the video for today, and we'll meet in a new video. We'll discuss certain important aspects related to constitution or law, and we'll try to explore some new topics. That's all for today. Jai Hind.